The court has a core bundle of 223 pages.
I haven't checked the pages. Yeah.
Supplemental bundle of 442 pages.
Yeah.
And an authorities bundle of 642 pages.
I'm going to look. I'm sure that's fine, yes.
In terms of housekeeping, the court will be aware that we submitted an application for a supplemental skeleton about 3 or 4 weeks ago. My learned friend, I don't believe, objects to that apart from paragraph 37, human rights argument.
Yes, the view we've taken on that, and I doubt if Simpson will object, is that we should certainly give you that permission. We were just cautious because we didn't know anything about the case at that point. And we will allow you to develop the paragraph 37 points di bene esse, because I think we will be in a better position to decide whether you should be allowed to develop the point when we understand how it fits into the rest of the argument.
Yes, my lord.
But that will be without prejudice, obviously, to any objection.
Yes, my lord.
Are you happy with that, Mr. Simpson?
Yes, my lord.
Yeah, good.
My learned friend submitted a supplemental skeleton earlier this week, to which we have no objection.
Well, now, there's been a problem with that. Actually, I think I did just get it. I have not read it because it didn't come to me until about an hour ago, and then I had a problem printing it. But it was printed just before we came. So I don't think I will be disadvantaged by not having read it. Actually, I'm not sure I have got it. Can I have another hard copy, Mr. Simpson? Have you brought more to court?
I'm not sure we have more.
Always unwise. Have you ever sent anything electronically? Oh, no. Here we are. I found it at last. No, exactly. It was my... no, something has gone wrong. It's very unlikely it'll have to be referred to today. If it is, I will just have to be over somebody's shoulder. Learning point, please, anything you send electronically, you should always bring a hard copy as well.
Yes, my lord.
My lord, I'm afraid I will be referring to that today, because in my submission it contains, or appears to contain, some significant developments of HMRC's position.
Well, in that case, we'll just have to manage somehow.
My lord and my lady,
well, I might just ask...
Would you like my laptop?
Yes.
I do have one spare copy that I can hand up. It's unmarked.
Oh, well, that's fine. That solves the problem. We have a spare copy, so...
Staple it, but,
I don't know why it didn't reach me when it reached my lord and my lady. These things, I'm afraid, sometimes happen. Thank you, Mr. Simpson. No, it seems to be all right now. Yes, right, well, we have that, yes?
What I propose to do, subject to the court's indications it's not necessary, is to briefly show you the statutory context.
Well, sorry, just one more thing. I also received, and this really only was this morning, a transcript of the entirety of the hearing in front of the judge.
Yes.
I don't know which party it was that wanted that, but I haven't printed it because it's a lot of paper. At the moment, I'm not quite clear why it's relevant.
Well, I believe it's in the supplemental bundle.
Oh, is it?
Anyway, but I think it was my predecessor who referred to that. I don't myself intend to refer to it.
Oh, right.
Because I don't see the relevance.
Well, okay. Well, we'll see how we go. Thank you very much indeed. I didn't realise it was in the supplementary bundle.
In terms of structure, therefore, I propose to briefly take you through the context, the statutory context, setting out how these rules operate and in what context they operate, show you some of the relevant factual documents that provide the background to this appeal, so you can see how we've got to where we are, make four preliminary points on my learned friend's supplemental skeleton, because I do submit they develop HMRC's case, or appear to, quite significantly from where it has been previously, and then to take you through the points in my supplemental skeleton, which are the key points in my submission.
Yeah.
In terms of the statutory context, then, we begin, please, in the authorities bundle, tab 1. with section 61 on page 10. Section 61 of Finance Act 2004. And you can see in subsection 1 the basic obligation to deduct a sum when making a payment to a contractor, say to the extent it's in respect of materials. In section 62, on page 12, we can see that a sum deducted under section 61 from a payment made by a contractor must be paid to HMRC, and is to be treated for the purpose of income tax, or as the case may be, corporation tax, not diminishing the amount. You can see in subsection 2, if the subcontractor is not a company, the sum is treated as being income tax. And then if it's a company, subsection 3, it's treated as being various things. We can see, if we follow this line of thinking forward, this is where the sum was deducted from the payment, and what happens in relation to that deduction that has been made. If we go forward to tab 2 in the regulations, please. Regulation 56 on page 46 explains that this regulation applies to sums deducted from contract payments made to a subcontractor, which is a company, to so much of any sum deducted under section 61 by contractor in a tax year and paid to HMRC, as is required, shall be applied in discharge of various liabilities. So that's where the scheme operates properly. You pay a sum, you deduct the amount you're supposed to, you hand that over to HMRC, it's then available for set off in these ways.
And just pausing there, the types of set off listed in subparagraph 2 are national insurance, PAYE, and I think construction industry, that sort of
Yes.
Liability.
Yes.
Rather than primarily,
Yes.
say, corporation tax on their profits.
Yes.
So that's relevant when we get to the provisions we're concerned with now.
Potentially relevant. Any balance is then, as you can see under subsection 3, repayable. Just to complete the picture where the sum has been deducted from the payment, still in tab 2, it's regulation 9, paragraph 10 on page 42, please, which specifies that if a contractor has deducted an amount under section 61 but not paid it to the HMRC, that amount is treated for the purpose of determining liability of any subcontractor, respective of whose liability the sum was deducted, as having been paid. That protects the position of the subcontractor, where there has been deduction.
Which regulation was that, Mr.
That was
Falk?
regulation 9, my lord, on page
41.
42. Regulation 9, paragraph 10.
Oh, yeah.
Right at the very end.
That would cover a situation, for example, where there's insolvency on the part of the contractor, so the amount's not
Logically,
paid, even though it's been deducted.
Yes. That deals with the situation where there was a deduction. Where there wasn't a deduction, we go to regulation 7, please, on page 40. And that specifies that a contractor must pay to the commissioners all amounts that is liable under section 61 of the Act to deduct.
For completeness, can we just put that together with the primary legislation?
Yes.
So my understanding is that the vares for regulation 7 is section 71, which is on page 29.
Yes, that would make sense. Sums required to be deducted. The credit mechanism that we see in section 62 and regulation 56 doesn't apply in this situation. That only applies where the sum was deducted. And I believe HMRC...
Sorry, say it again. Credit mechanism which we see in...
section 62 of regulation 56.
Yeah.
That only applies where it has been deducted.
Yeah.
Which makes sense, because in this situation, the contractors received the full payment without deduction, so why would they get credit for that? HMRC seem to agree that's their original schedule.
Sorry, I'm being slow. It makes sense because...
They received the gross payment. They received the full payment. So if they receive a net payment...
Yes, I'm seeing, yes.
They get the benefit.
You know, of course, yes, yeah, I said I was being slow. Yep.
As I said, I believe that's common ground. HMRC's original skeleton for this hearing, paragraph 17. Where the amounts are not paid to HMRC, that's when we get into regulation 13, which is on page 44. And you can see paragraph 1, this regulation applies A, if there's a dispute, B, if HMRC have reason to believe that there may be an amount payable for a tax year under these regulations that's not being paid, or C, HMRC consider it necessary in the circumstances. And under 2, HMRC may determine the amount which, to the best of his judgment, the contractor is liable to pay under the regulations and serve notice this determination on the contractor. So that's the regulation 13 determination that you've read about in our skeleton argument. We'll come back to regulation 13.3. That's obviously of critical significance to this appeal. We go please then to paragraph 5 of regulation 13. A determination under this regulation is subject to parts 4, 5, 5A and 6 of the Tax Management Act, as if the determination were an assessment and the amount determined were income tax charged on the contractor, and those parts of that act apply accordingly with any necessary modifications, except that the amount determined is due and payable 14 days after determination. So that brings in the procedural provisions of the Tax Management Act. If we could go then please to tab 4, we have various provisions of the Tax Management Act. On page 60, we have section 30A.
Sorry, just one moment. Yeah.
Title is, or the heading is Assessing Procedure. And in subsection 4, after the notice of any such assessment, for which we read determination, has been served on the person assessed, the assessment shall not be altered except in accordance with the express provisions of the Taxes Act. In terms of express provisions, we have a right of appeal over the page on page 61, section 31. And in section 31, subsection 1, paragraph D, an appeal may be brought against any assessment, which is not a self-assessment. The procedure for making an appeal is in section 31A. See, the notice of appeal must be given in writing within 30 days to HMRC in the first place. And in subsection 5...
Sorry, where was that?
Apologies. So we're in section 31A now, which is on page 63.
Oh, I see. Right. Yep.
And so you can see procedural requirements for an appeal within 30 days to HMRC in the first place. And at subsection 5 on the same page, the notice of appeal must specify the grounds of appeal.
If you were appealing against a Section 13 determination, would it be a valid ground of appeal for the contractor to say, well, your determination was correct when it was made, but the subcontractor has since paid all the tax due, and therefore nothing's left?
In my submission, you can rely on condition B to appeal a regulation 13, yes.
You could rely on condition B in regulation 9, is that?
Well, you could make you could rely on a ground of appeal to the effect that a regulation 9 direction ought to be made, yes.
Well, that's a slightly different point.
So my lord's positing, well, what if they haven't paid at the time of the regulation 13?
When the determination under regulation 13 is made, the
yes.
subcontractor hadn't paid
Yes.
what was due by way of income tax or corporation tax.
Yes.
But by the time that an appeal is launched,
Yes.
it's been paid.
Yes.
Could that be a ground of appeal against a regulation 13 determination? That's my question.
In my submission, yes, because regulation 9 doesn't specify when the tax has to be paid. So if the condition comes to be met by the time it comes to be considered by the first tier tribunal, why shouldn't it take notice of the facts existing at that date?
Even though there's no right of appeal against condition B in regulation 9.
Well, that's the situation. My little friend seems to accept now, and this is why supplemental skeletons is relevant, that you can appeal a regulation 13 on the basis that a regulation 9 direction ought to be made, which must therefore include considering conditions A and B. My lord then posits, well, what if conditions B is not met at the time but comes to be met? My answer to that is you should consider it as at the date it falls to be considered by the tribunal. And that makes sense because you bear in mind condition B is looking not at your tax position, it's looking at the tax position of someone you may not have, other than a contractual relationship, have no knowledge of their tax affairs. To complete the procedural picture, we've got the basic time limit for assessments and therefore regulation 13 determinations in section 34 on page 65.
Sorry, just before we leave the last point, am I right in thinking that there has been a Reg 13 appeal?
Yes.
We don't have any of the papers relating to it, do we?
Not that I'm aware of, no.
I think it would be of interest for us to see them. Could they be supplied overnight?
Oh, I'm sure they can.
I don't know how far it's got, but there's been obviously grounds of appeal and presumably some sort of response before it was stayed.
I would have to check. I haven't.
Well, whatever there is, could we have?
Yes.
Thank you.
Section 34 therefore provides the basic time limit. As the court will no doubt be aware, there are extended time limits for carelessness and deliberateness, but in terms of showing you where the ordinary time limit is, it's 4 years. We then come to the situation where there hasn't been a deduction, and so although you have a liability to make a payment under regulation 13, there's not going to be credit for that, and that's what's dealt with in regulation 9 on page 41, please. Behind tab 2.
Ben, is it possible, I'm not sure it's that clear, to tie regulation 9 back to the primary legislation? I mean, there are some sort of broad general provisions in the primary legislation, which I assume are thought to be the basis of regulation Regulation 9. I'm not suggesting for a moment that there wasn't power to make the regulation, rather that understanding the framework of the primary legislation may be relevant to construing.
My lady, yes, I'll give that thought tonight and come back to you tomorrow morning. We can see in paragraph 1 this regulation applies if it appears that the deductible amount exceeds the amount actually deducted and condition A or B is met. Essentially, paragraph 2 then tells you the difference between the deductible amount and the amount actually deducted. And then we have condition A, which is satisfying HMRC that he took reasonable care to comply with section 61 of the Act, and that the failure was either an error in good faith or there was a genuine belief. Condition B is then that an officer is satisfied that the person to whom the contractor made the payment either was not chargeable to tax on those payments or has made a return and in which those payments were taken into account and paid the income tax or corporation tax due and made a request under B.
For A to apply, you don't have to have made a request for a direction, i.e. there's no equivalent to B.
Correct.
Do you know why that is? It seems an oddity, but perhaps there's some reason I would understand if I understood it properly.
No, and it's even more of a puzzle than that, because if you read paragraph 4B, it doesn't say you have to make a request of direction under condition B. It says if you request a direction and separately HMRC is satisfied with those things, and HMRC may not be able to share with you the basis on which they're satisfied, because this could involve looking at confidential matters relating to another tax.
Right, again, I'm being slow. What's the point you're making?
The request referred to in 4B doesn't specify it must be a request for direction in reliance on condition B. So if you requested on a direction at all,
surely it must mean under B, because it's an and with A.
my lord, it doesn't say that. And as I said, the contractor himself or itself may not know whether condition B is satisfied.
Yes, there's a difference there between condition A, which is obviously looking at the position of the contractor and saying, has it taken reasonable care, etc.
Yeah.
And condition B, which, as you say, relates to the position of what is potentially a third party, about which the contractor knows very little.
Yes.
But as I understand it, the point you're making is that the request made under condition B could just be a request to make a direction for whatever reason, whether it's condition A or condition B.
Because if it's envisaged that there'll be a request that then explains the reasons why condition B is met, that may be somewhat unrealistic, because in unrelated third-party situations, how will you know? The person who knows will be the taxpayer, and usually HMRC. They'll be able to look at the internal files.
As you say, that depends whether a third party is in fact a related party, where realistically you'll be able to see what they've done.
Well, that can be the case, but equally can very much...
No, I understand that. No, I'm just saying that...
I accept in this case it was the case, which is why we do assert that the tax was... the income was returned, tax paid, but it has to cover the generality of cases.
As I understand it, that oddity which you have, or that point you have just made, wouldn't be an explanation for there not being an equivalent to B in subsection 3. That's something you just don't know about.
No, I mean, I
can't see a rational
I think it's been noted that condition A says you must satisfy HMRC of something, and
the contractor's got to do the satisfying, so
exactly
the contractor will have to approach HMRC one way or another.
But
yes, I see. No, that may be the answer. Yeah.
But I suppose you could satisfy HMRC without having any knowledge of Regulation 9. If you say, well, I'm really sorry, this is how it happened, no knowledge of Regulation 9, you may nevertheless have satisfied them of the conditions in condition
Thank
A.
you.
So beyond that, I can't explain it now.
No, well, that strikes me as prima facie a reasonable explanation. If, when he gets to his feet in due course, Mr. Simpson has a different answer or can confirm that answer, it would be, or those behind him, it would be useful to know what it was. But anyway, thank you. That's as helpful as you can be.
Regulation 9.5, an officer may direct the contractor is not liable to pay the excess to HMRC. And then we get into the right of appeal in relation to condition A. Well, sorry, the refusal notice. So it says, if condition A is not met, an officer may refuse to make a direction under paragraph 5 by giving notice to the contractor stating the grounds for refusal and the date on which the refusal notice was issued. Notably, it doesn't say that you may issue a refusal notice based on the existence of a regulation 13 determination. The only ground on which you can issue a refusal notice is condition A is not satisfied. Equally, the only ground of appeal in relation to a refusal notice, we can see in paragraph 7 and 8, is essentially that you did meet condition A.
Is there any reason why you can't appeal against the revenue decision that condition B isn't met? Is that to do with the confidentiality of the tax affairs of the third party?
My suspicion is that that's probably the thinking, but I don't know. That's the only sense I can see in it, is that, well, you may not be able to deal with that issue because you don't know, whereas you will know about the reason for your own error as per condition A, my lord.
I mean, it's odd that there is this condition which seems to be unchallengeable.
Well, you'd have to go to judicial review.
But maybe, as you say, the confidentiality point at least provides an explanation for that, rather than perhaps indicating that there is supposed to be some other sort of substantive difference, if you like,
Yes.
between the consequences of meeting condition A and condition B. And I think you come back to that in your submissions.
It would be a rather odd judicial review, though, wouldn't it? It would be contractor saying to the administrative court, revenue and the subcontractor can't agree on whether the subcontractor's paid everything that he should. We want you, the administrative court, to decide that.
Yes.
And it's not my tax affairs we're asking you to decide, it's somebody else's.
Yes. But logically, that must be where it leads, because there can't be no control over that decision under condition B. There's no right of appeal that we can see here, so that must be what it involves. You may experience difficulties in challenging that if your subcontractor is not prepared to cooperate and say, well, this is the information we provided. That's the route that we can see.
Well, again, when in due course he gets to his feet, if Mr. Simpson can add anything to our speculation about the reason why there isn't a right of appeal against condition B, it would be useful to have it. Those behind him will probably have some idea about it.
The point I was just making, therefore, was that there is no basis for HMRC to issue a refusal notice on the grounds of an extant regulation 13 determination, and nor does that form part of the appeal if HMRC issue a refusal notice. And if we look at paragraph 9, what the tribunal does on appeal is not consider regulation 13 or anything to do with that. It says if on appeal, under paragraph 7, that the refusal notice should not have been issued, the tribunal may direct the officer to make a direction under paragraph 5 in amount the tribunal determines. And so this all operates by reference to condition A. So if HMRC subsequently issue a regulation 13, that doesn't interfere with the decision the tribunal's got to make here, because it's only concerned with the refusal notice, which is only concerned with whether condition A was met. In my submission, it is necessary and implicit in Regulation 9 that HMRC must comply with the direction. It doesn't say that, but the legislation says HMRC can be directed to do something. My submission, they must do it, they have an obligation to do it, and it's also, at least implicit, that they have the power to do it.
So comply with direction, you mean comply with the tribunal's decision that a direction should have been issued?
Yes, because in the regulation 9.9, the tribunal can direct a
It's
direction.
the actual word, the tribunal makes a direction. Well,
Yes.
a direct is just another word for an order, so
Yes.
obviously that they have to comply with
Yes,
it.
yes.
So it's implicit, it's explicit.
And the other side of that coin is HMRC must have the power to comply with that order.
Well, if it has an obligation to comply with it, it has a power to comply with it.
Yes, exactly.
All right.
We then return to Regulation 13.3 to look at the way these two provisions are intermediated. And I'm sure this has been looked at very carefully in the lead up to the hearing, but there it is, and I'll be saying much more about it later. Showing you briefly, unless the court considers it unnecessary, how we got to where we are in this case, I was going to take you quickly through some key documents in the the supplemental bundle, beginning with the warning letter of 18th of January 2019, which is behind tab 9. You can see over the page the statement just below the bullet points. After we've raised the determination, we cannot consider any initial or further claims under Regulation 9.3 or Regulation 9.4, the amount shown in the determination. And that becomes the consistent theme of HMRC's correspondence. The determination in relation to Beech is behind tab 21. 344,000.
Sorry, behind tab 11?
21, my lord.
Sorry, 21.
My lord asked about first tier tribunal proceedings. We do actually have the initial appeal to HMRC against that determination. Tab 28, please. Sorry, not tab 28. Tab 27, apologies. So on the 5th of April, there's an email attaching various appeals, and if we go forward to page 234, we can see the appeal relating to Beech. And you can see there the company is explaining that it was under a misconception, this is the third paragraph, that as the company and the contractor had been under the common control, Mr. Beech, they didn't need to operate CIS. There was a misconception. It then refers to condition A.
So the terms of the appeal engage condition A in Regulation 9 and is obviously in terms an appeal against the Regulation 13 determination.
Yes, this is the Regulation 13 appeal, yes.
Yes, but my point is that it engages condition A, which has its own appeal.
It's relying on condition, it's saying, yes, it's asking HMRC to accept an appeal on the grounds that condition A was met, yes. In the 5th paragraph, you will know from your records that immediately upon realising the error, the contractor registered for gross payment status in order to regularize the position, and this which demonstrates the failure to comply was made in good faith. Proceeding with the determination inevitably results in considerable liability under CIS for the group, the corresponding asset within the contractor. Furthermore, the contractor would essentially be overpaid.
So sorry, you're just reading the rest. Yeah.
Just reading the bottom, overpaid. And it asks HMRC to review the determination.
So it's your case, is it that it is legitimate in a Reg 13 appeal to rely on condition A where no attempt has been made prior to the determination? Well, oh, sorry, I only have to say it to see it's obviously your case.
Yes.
Yeah.
And notably, HMRC in their supplemental skeleton accepts something along these lines. Paragraph 17, this is one of the things we're going to come to shortly.
Let's have a look.
So there's an argument that HMRC don't have the power to withdraw, but they do have the power not to collect a Regulation 13. Then at 17, my learned friend says, even if HMRC have no power to decide not to collect a Regulation 13, so the only course is the assessment to be cancelled. No practical difficulty. This is because it's common ground that HMRC have a power to cancel an assessment once a taxpayer has given notice of an appeal. Giving such a notice is a straightforward task. The ground of appeal would either be error of law in the fact pattern described in the appeal on the basis that HMRC were already under an obligation to issue a Regulation 9 direction, or bad faith. I'll come back to that later, but just so the court has that in mind as we go through. Returning to the supplemental bundle, at tab 28, we have a letter from HMRC acknowledging the appeals and seeking confirmation that the tax is requested to be postponed. HMRC set out, as I said, a recent timeline of events at the bottom of page 336. You can see from that that information was promised to HMRC but not provided before HMRC issued the determination. Various reference to Daniel saying information would follow, and then HMRC appearing to lose patience and issuing the determination. And then
why is that material to any of the legal issues?
It's not, my lord. I'm just giving you the background here. So.
I mean, the fact is that you were given a clear warning.
Yes.
And which explicitly said you'll need to make an application or may need to make a request for a section 9 for a regulation 9.5 direction, and you didn't.
Not prior to the determination. That's correct, my lord. You can then see under the heading Regulation 9.3 and 9.4. You will have seen that the warning letter invites a claim under 9.3 or 9.4. HMRC usually allows 30 days, but as mentioned, 60 days were allowed. However, the letters also point out that once HMRC has raised the determination, we cannot consider any initial or further claims under Regulation 9.3 or 9.4. Therefore, while it's perfectly possible for you to appeal against the amount, it's now too late to claim under Regulation 9.3. There's a phone call referred to behind tab 29. In the second paragraph, HF asked what recourse is now possible given these very large determinations would be liable to put the companies in liquidation. I said, as far as I was aware, once Regulation 30s had been issued, the regulation would include a 9.3 claim, and certainly never seen one. I pointed to the timeline in my letter and the fact I had 60 days. We're looking to the possibility of a late claim. We get the view of the matter letter behind tab 30, which is essentially, in terms, my view remains the same as it previously was. That's in the third paragraph.
So is this a review or not? Formal review?
No, so when you appeal to HMRC, the first thing HMRC have to do is the officer who issued the decision sends you a view of the matter letter to see if your grounds of appeal have changed their mind. When they write back, as they often do, saying, no, it hasn't changed, they will then offer you the review.
Okay, so this view of the matter letter is not sort of a formal statutory step.
No, it is a formal statutory step. They do have to do this.
Okay.
And at the same time, they then offer you the review, and
Thank
you can
you.
see that over the page.
I see.
The review letters are at tab 36.
Yes, my lord. So if we please go to tab 36, we can see 9th of July 2019. And on page 260, in the first full paragraph on that page, unfortunately, once a determination has been issued under Regulation 13.2, Officer Merton was precluded due to the provisions of 13.3 from considering either initial or further claim under 9.3 or 9.4 for a direction granting relief. The formal request in relation to 9.4 can be seen behind tab 42, October 2021.
So by this stage, presumably, although we haven't got the papers, the appeal must have gone to the FTT following the review.
Yes, it would have
we've
gone
just
within
taken.
30 days of the review conclusion. Yes.
And so that review conclusion letter is in 2019.
Yes. Page 289, you can see the view is put forward for the taxpayer. Accordingly, in our view, the absence of a time limit within the Act in relation to direction to 9.5 on the basic condition B allows the appellants to now request the hedge sums.
Sorry, where are you reading?
I'm on page 289, my lady,
Thank you.
in the middle paragraph beginning accordingly.
But there's already been a review, hasn't there? That's what we saw at tab 36.
There's been a statutory review of the decision to issue the Regulation 13, yes. But this is now the formal request, insofar as one hasn't been previously made, to rely on condition B, my lord.
I see.
But the real substance of it is the request for a direction to be made under Regulation 9.5.
Yes, that's what's happening here, yes.
So just to understand this, is that better, if I may? The condition A point had already been engaged by the appeal.
Yes,
The appeal
yes,
to the FTT.
yes.
I think what you're saying is that this letter, for the first time, engages condition B.
This is I think this is the first explicit reliance that I've seen. I wouldn't want to go on the limb and say it's definitely the first reliance, but from what I've seen in the papers, it's the first explicit reliance on condition B.
And the first explicit request for a direction under regulation 9, maybe. I'm not sure the appeal is put in quite this.
I'd want to look carefully into that, my lady, because condition A is clearly straight away in point once the regulation 13.
Indeed.
Yeah, so then page 219, so on and following goes on to explain why you say that the subcontractors paid everything that's due.
Yes. Yes, ma'am.
You were cautious in accepting my lady's suggestion this was the first request for a direction under 9.5. That was because the correspondence and all the tribunal papers we haven't seen may include references to 9.5 in the context of condition
Yes.
A, even though there isn't an express linkage in the regs between condition A and regulation 9.5.
At the very least, it's wholly implicit in what's gone before that the taxpayer did want a direction in regulation 9.5, because that's the discussion that's being had. They're saying we meet condition A. HMRC is saying, sorry, we can't consider condition A. I mean, if that's not a request for a reliance on regulation 9.5, then in my submission, it would be read in context.
It goes back to your point that the request for a direction in relation to condition B doesn't say it has to be a request relying on condition B. You say we've already requested it. We requested it, albeit that we talked about condition A.
Yes, and once, and that fits in with the point about confidentiality. So HMRC being on notice that you wish to rely on regulation 9 arguably imposes, subject to HMRC not being able to consider it at all, some sort of duty on HMRC to go and see what their own papers say about has the subcontractor or the contractor actually paid tax, because that may not be something that the paying company has any access to. Tab 43 is the letter that prompted the judicial review.
I
The
don't.
decision that is the subject of the judicial review. That's fine, tab 43.
Sorry, the other bundle.
Well, I think that's the letter that I've got in tab 17 of the core bundle.
Tab 17. Sorry, my
If it's the letter of the 13th of December 2021,
yes.
which I understand to be the decision that prompted the
Yes.
JR, I've got that in tab 17 of the core bundle.
Yes, my lord. I apologise. It's in two places then, but chronologically, well, it makes sense. It's in the core bundle. It's the decision under review.
Yeah.
Chronologically, this is where it fits
Right.
in. And you can see on page 408, I'm unable to give any consideration under regulation 9.4 as the representation made under this regulation have been submitted too late. I trust this position. So that's an unequivocal statement. We just can't consider it. It may be relevant to show the court at this point paragraph 21 of my learned friend's supplementary statement, because in my submission that departs from what is said there. So this is in the context of talking about appeals against refusals. But at 21, my learned friend says if the refusal is upheld, so you're not getting a condition A regulation 9.5 direction, prior to collection, HMRC would in any event check whether the grounds set out in regulation 9.4 were met. To the extent that they had been met, HMRC would not collect the amount due under the regulation 13 determination. This would be an exercise of their collection and management powers. So far from saying we cannot and will not consider regulation 9.4 after a regulation 13 has been issued, this says in terms, well, we will consider regulation 9.4, not with a view to making a regulation 9.5 direction, but with a view to exercising a power of care and management or to collect the regulation 13. So in my submission, that does depart from what is said in the letter that is the subject matter of this judicial review, because that letter says we cannot give any consideration under regulation 9.4. Whereas my learner friend now says, well, we definitely will. And my submission, that's that they definitely should. The difference between us is in what framework. My learner friend says, well, the only way we do that is under powers of collection and management. Whereas I say, well, no, you can just do it as part of the ordinary operation of regulations 9 and 13.
I'm not sure I've quite understood what Mr. Simpson will obviously have to explain, but the factual scenario that he's positing here, I think, is that the taxpayer, the contractor, has failed to satisfy the HMRC under condition A, and so the revenue have issued a refusal notice under regulation 9. The contractor appeals to the FTT, and the revenue's decision to refuse condition A is upheld.
Yes.
So the FTT has decided that HMRC were correct not to refuse to issue the 9.5 direction. But nonetheless, Mr. Simpson says, HMRC would reconsider that decision, even though the FTT has upheld it. Is that
No,
what 21 is saying?
9.4 is condition B, my lord. So condition A, you failed before the first tier tribunal.
Oh, I see.
But nevertheless, before they enforce the regulation 13, so there is an extant regulation 13, before they enforce that, HMRC would in any event check whether 9.4 was met. And to the extent that it was met, they wouldn't collect the amount due. That's what that's saying.
Okay, so you've lost on condition A.
Yes.
Nonetheless, revenue will then have another look as part of their collection and management functions at whether condition B might be important.
Yeah, you've lost on condition A. There is a regulation 13, but before they enforce it, they will consider regulation 9.4. That's what I read this as saying. It's important that there is an extant regulation 13. This is not saying we will then consider not making a regulation 13 if we're satisfied that 9.4 is met. It's saying there is a regulation 13, and before we decide to enforce and collect that amount, we will give consideration to 9.4. That's in terms what that is saying, Mike, as I read it.
And presumably, again, this may be a matter Mr. Simpson will have to help us on, that would generate some paperwork to the contractor saying, notwithstanding that your challenge to the determination has failed, we've now had a look, the subcontractor has paid, and therefore, they won't say therefore your liability is discharged, because technically that would be incorrect. Therefore, we do not think it right to collect.
That's as I understand it, what Mr.
And you would need to get a bit of paper like that formally to know where you were.
Yes.
It would be an odd position because they would be required explicitly or at least implicitly to assert that you were still liable for it. If you just say we'll never collect it.
Yes, I mean, if the decision is in accordance with the terms of paragraph 21 that the grounds are met, then logically they have to tell you that. Otherwise, you'd be sitting there waiting for the.
Well, exactly. I'm really just thinking about. It's not focused on any particular consideration, what I might call rule of law or good practice considerations. If you think you have a bill for £1 million, and you've just lost a challenge to that, if the revenue do not think it right to collect it, they have got to give you some bit of paper which effectively, though this is not the correct legal analysis, effectively discharges that liability. Which when they're drawing up their accounts and so on, they can say this amount isn't due.
Technically, what you've just lost the challenge to is not the regulation 13; it's the regulation 9 refusal notice. That's the hypothesis here. Is that
I see. Sorry, I wasn't reading it sufficiently carefully. But my broad point still.
It's tantamount to discharge, but it's just saying it'll stand there and we won't collect it.
I mean, can I just add another point into the mix there, which is you showed us earlier that you're supposed to pay a regulation 13 determination within 14 days.
Unless you appeal it, then you can dispose.
I see. So it assumes that
Yes, because
Okay, because the postponement provisions in the Taxes Management
Yes.
Act are brought in. But
Yes.
nonetheless, it's reading paragraph 21 on its face, that suggests you might end up with a different treatment if you had already paid it because you hadn't sought postponement or you didn't meet the conditions.
I'm not sure if Mr. Simpson was intending to that much nuance. Presumably you've paid it because, I mean, frankly, if you're appealing the Regulation 13, you will apply for postponement and get postponement. There's no hardship.
If for some reason,
Yes.
I may be misremembering this from the Woolwich case many years ago, you do suffer interest disadvantages if you
Yes.
so you might say, well, I think I'd rather pay now and get the money back afterwards. In which case, presumably, we'll have to ask Mr. Simpson, you get the money back.
That would have to logically follow, otherwise it'd be fair and fair.
There was it was 20 years ago or longer, in the Woolwich, very much this debate happened in the Court of Appeal, where the majority said there's a right of restitution, which was eventually upheld. But Lord Justice Ralph Gibson said, no, that would be a sort of requirement of good practice, but not a right of restitution for the revenue to pay back money, which they would, of course they would. The difference between the two, of course, was that if there was a right of restitution, there would be a statutory right to interest. Whereas if it was just the revenue giving you money back as a matter of good practice, just they thought it was morally wrong to hold on to it, there wouldn't be.
Yes.
But I'm not sure this helps really, but we're just in that territory of effectively discretionary repayment.
Well, it's in the sense it's not just the logic of that, in my submission, would lead to the conclusion that the HMRC ought to, as a matter of at least public law. If that's right.
Well, yes, all right, but in a sense that's what I mean. It's
Mr. Simpson places all of this in the public law section. He says none of this operates under Regulation 9.5. This only operates as a matter of HMRC's powers of care and management. And using those powers of care and management, we will, before we enforce a Regulation 13, check whether Regulation 9.4 has been met because the subcontractor is paid. And if it has, then we will exercise our power of care and management not to collect.
But in the context where the revenue is already holding the money.
Yes.
And by the way, postponement, as I recall, falls away if you go above the first tier tribunal. So, but if the revenue is still holding the money, it's quite stark to say that the revenue would, as a matter of their care and management powers, repay money which the revenue say they don't have to repay, and which they say is required for public services.
Yes.
That they nonetheless will do so. You could imagine that the National Audit Office might have something to say about that.
Well, this may all be a reason why it makes far more sense to operate this under the Regulation 9 framework, which is my submission, rather than trying to find a power in care and management. That's one of my submissions, that Mr. Simpson, based on this supplemental skeleton, ends up within a hair's breadth of me. I think the only point he doesn't bring himself in full line with me is to say, well, you can't actually issue the Regulation 9.5, but you can achieve essentially the effects of it through various points that he makes here, and I'm going to refer to those as my preliminary points shortly. But I just wanted you to see the
You say that he puts it all in the public law box, the general public law box, rather than into the proper interpretation of the regulations.
That, but not even that, my lord, because as I showed you in paragraph 17, he accepts that a valid ground of appeal against the Regulation 13 is the HMRC, not that they've issued a Regulation 9.5, but they ought to have issued. In which case, that puts within the Regulation 13 appeal the question of whether HMRC ought to have issued a Regulation 9. And in order
under condition A? No, you say condition
well,
B.
logically, this must cover condition A or B. It just says, paragraph 17, on the basis that HMRC were already under an obligation to issue a Regulation 9. And that could be condition A or condition B. It doesn't specify one rather than the other. And so Mr. Simpson puts all that in the Regulation 13 appeal box. Logically then, and he has to do that in order to allow the Regulation 13 not to become final. And then logically, if that's right, when the first tier tribunal comes to consider the matter that is the subject of the appeal, that is part of the matter that must be then determined. So it doesn't all, that's what I'm saying. Mr. Simpson gets very close to a system where you can have a regulation 9.5 in substance, but just not in form. The one thing you can't do, I think Mr. Simpson says, is you can't actually have a regulation 9.5, but you can get very close to it in various different ways. And my submission obviously is the simpler approach is just to say, yes, you can. The submission I was just making was to contrast what is said in the letter, the decision letter, at page 408, with what HMRC now said. In my submission, they're different. They contradict each other. HMRC said we can't consider regulation 9.4. They didn't say we can consider it, but just not issue a regulation 9.5. They just said we can't consider it. Whereas now HMRC is saying, well, we will consider it. The letter before claim is at tab 44, 409. I'm not sure there's anything in there you need to see because I'm going to explain what our case is. HMRC's reply is at 416, and that maintains the point that you've seen previously that they can't consider it. So at page 420, paragraph 19, as the defendants tab 45, page 420, paragraph 19. As the defendants had issued the Regulation 13 determinations, they were unable to consider the Regulation 9.4 position put forward by the claimants. As Regulation 13.3 operates to prevent directions being issued under Regulation 9.5, HMRC warned you about this. So that's we can't consider condition B. Turning then, please, to the core bundle, just to finish this off. The the judicial review claim form is at tab 16. On page 212. See the decision, details of the decision to be judicially reviewed in 3.1. The decision was issued by the defendants under CIS, by which the defendants refused to consider an application. The defendants apply the relieving provisions in 9.4 and make the appropriate direction. The effective decision is that the group companies and others will suffer double imposition of the same tax. Relief sought on page 217, quashing order of HMRC's refusal to consider the reliance on Regulation 9.4 and not make the appropriate direction. HMRC's detailed grounds of resistance are behind tab 9, and they make similar points to that which we've already seen, but I'll just show you them quickly. So on paragraph 23.
So which page is this?
So this is page 119, my lord, behind tab 9 in the core bundle.
Oh right, sorry, it goes backwards, yeah.
Paragraph 23 says, for the avoidance of doubt, and though not strictly relevant, HMRC do not accept that the information provided is sufficient to demonstrate the conditions set out in Regulation 9.4 being met.
But they are real points in footnote 4, isn't it?
Yes, well, it's paragraph 24, my lord.
Yeah.
It's it says an officer has reviewed the information provided and noted it was possible the condition in 9.4 has been met, but the information received was too high level. And then in 24, HMRC wrote to the claimants rejecting their request, as stated in the warning letters. Regulation 13.3 prevents consideration of any claim under Regulation 9.4 after the issue of Regulation 13 determination. The same points then arise in my learned friend's skeleton argument for the High Court, and indeed the original skeleton argument for this hearing. I don't know if I need to show you them. Paragraph 2 and paragraph 60H make the point that you've already seen. And that brings us up to date, apart from my learned friend's supplemental skeleton, which I've shown you in my submission, takes matters further and in a different direction than HMRC had previously appeared to accept. And I would make, I've summarised in my own supplemental skeleton the reasoning of the High Court. I don't think, unless the court indicates otherwise, I need to take you through that. I'm sure you've read and considered the decision below, but there is a summary at paragraph 5. I'm going to deal with those points as relevant when I go through the detail. But before I do go through the detail, I did have 4 preliminary points arising out of my learned friend's supplemental skeleton argument. Perhaps it is relevant actually to remind the court that an important part of the High Court decision was the supposed power to withdraw a Regulation 13 determination. So just to remind the court, if it needs reminding, it's tab 8, we're looking at a High Court decision which the court may have separately, but tab 8, and at 51, because what the High Court does is it says, well, yes, our interpretation does leave open the possibility of abuse, but then it seeks to deal with that at 51 and 53. It says, importantly, this is page 111, apologies. Importantly, HMRC has the power and ongoing power to withdraw a liability determination. The exercise of that power of withdrawal itself attracts not only merits questions from HMRC, but also basic and legally enforceable public law duties. A consequence of withdrawal would be that the preclusive consequence, the extent liability determination, so that's the Regulation 13 determination, would be lifted. So the clear reasoning here of the High Court is, you, HMRC, have a power to withdraw a Regulation 13 determination. If and when you do, that will enable you then to make a Regulation 9.5 direction, and so it all works quite neatly. In my supplemental skeleton, and I'll come on to this, insofar as it needs making good, but I set out that that's wrong, because I've already shown you section 38.4. I referred to Bayliss and Gregory, which says actually, no, you can't, except in accordance with the express provisions of the Taxes Act. So there's not a general care and management power to withdraw. Mr. Simpson's supplemental skeleton argument doesn't contradict that as far as I can see. Instead, what he says is that there is a power not to collect. So although the Regulation 13 can't be withdrawn, HMRC cannot collect, decide not to collect it. And we can see that in paragraphs 13, 15, and 16. So in particular, at paragraph 16, Mr. Simpson says, what is prayed in aid against HMRC's position is section 38.4. However, the only thing it expressly prohibits is the assessment being altered. It says nothing about not collecting money due in terms of an assessment. And this is important. This is very important because it means we've already gone away from what the High Court decided. Because the High Court is a very important part of the decision. You do have the power to withdraw. That then lets you consider Regulation 9.5. In light of section 30A, subsection 4, that's not correct. And Mr. Simpson doesn't seek to justify that as being correct. He says, well, we can just decide not to collect it. But that's very different. That's fundamentally different, because if you just decide not to collect it, the Regulation 13 stays in place and the preclusive effect stays in place. And so we're already some distance from where the High Court sought to justify its decision. In fact, a key plank has fallen away. So that's my first preliminary point arising from my own friend's skeletons. The second is that I now see very little practical difference between the parties. My case is that HMRC can consider an issue a Regulation 9 direction after a Regulation 13 determination has been issued. That's my case. HMRC say, well, we can't do that, but we can and will consider whether the Regulation 9 conditions were met, and if they were, we will exercise our power of care and management not to collect the Regulation 13 sum. In other words, they will consider the very conditions that supposedly Regulation 13.3 means they're not supposed to be considering after a Regulation 13 determination.
Just hang on 1 second. Sorry, just wanted to.
So in effect, what you're saying is that HMRC's position is self-contradictory because Regulation 13 on their interpretation says we can't consider it, but they say, well, anyway, we will.
Yes.
Even though we can't, we will.
Exactly. Using a power of care and management, yes.
But another way of putting,
No,
another way of putting it is that the decision that you are challenging, that was challenged on the judicial review, was a decision that they could not consider the position.
Yes.
And
Now they're saying we
you're
can.
suggesting that they're now taking a different line.
Yes. I mean, it makes sense what they're saying. It makes sense in practical terms. In legal terms, I disagree, obviously. But that they wouldn't go and collect when they are satisfied that the subcontractor has already paid. That makes sense. I think that's where this submission comes from, although Mr. Simpson wants to explain it. But once you've gone down that route, why stop there? I mean, unless we're compelled to stop there, why stop there? And that's why this second point is to wonder rhetorically what purpose is served by HMRC saying, well, we can't actually consider an issue of Regulation 9.5. We can do something very similar. We just can't do the one thing that Regulation 9 provides for. I mean, if there was some insurmountable linguistic hurdle that meant they couldn't, fine, but we don't see that. And my submission, when I get to it, I'll make that point good. The third preliminary point is one I've already made, so I won't label it.
Hang on 1 second, sorry. Yes, sorry, do go on.
So my third preliminary point is one I've already made, so I won't labour it, but it's that HMRC now accept you can appeal a Regulation 13 direct determination on the grounds that a Regulation 9 direction ought to be made. And that's paragraph 17.
Yeah.
And the significance of that is that a legitimate ground of challenge is accepted by HMRC to a Regulation 13 determination. It's not simply that there is a Regulation 9, but that there ought to be a Regulation 9. And so Regulation 9 manages to have a preclusive effect even when there isn't one. But and logically, on appeal, the FTT will have to consider whether Regulation 9 conditions are met, because that's the ground of appeal. It's a valid ground of appeal. That then carries its way through the procedural machinery to be the matter to be determined by the tribunal. And so the tribunal...
Just in that context, possibly not now. I'd like to understand a bit better how the FTT goes about that. Because in relation to condition A, it's obviously it's got the obvious jurisdiction to do so.
Yes.
It's a bit less obvious, to be fair, in relation to condition B.
Yes.
Which obviously is in terms of revenue being satisfied and the revenue having about certain factual things and the revenue having a discretion.
Yes.
So there is a potential difficulty there that maybe needs elaborating.
Well, I mean, I put this slightly differently at this point. The way I put this is a Regulation 9 will be made. And then that allows the Regulation 9 procedural machinery to operate in its own way, which would be a statutory appeal for Condition A, and if not satisfied on Condition B, judicial review.
Can I maybe understand it this way? Let's say there's an extant Regulation 13 determination which is under appeal.
Yes.
One way or another, whether it's through the threat of judicial review or whatever, during this process, before the Regulation 13 determination is finalised, the revenue becomes satisfied or are told to be satisfied that Condition B has been met.
Yes.
I think your point is that they can at that stage, or should at that stage, issue a Regulation 9.
Yes, and then that provides the grounds for allowing the Regulation 13.
I can then see that the FTT has got a job to do.
Yes.
It can say, well, we've got a Regulation 9 determination, so that under the terms of the regulations, that cannot.
That's the way I see it working.
Okay.
Yes. Because one of my points, as you've seen from my skeleton, is there has to be some way of linking Regulation 9 into being a ground of appeal for Regulation 13 because of Section 38(4). The way I do that is as just described, that there will be a Regulation 9, which then provides the virus to say, well, now the Regulation 13 appeal can be allowed. The point I was making under preliminary point 3, though, is just to emphasise again that once you've gone that far and you said, well, Regulation 9, or the fact that a Regulation 9 ought to be made, is a ground of appeal against the Regulation 13 determination, what possible reason can you give for saying HMRC don't have the power to actually issue the Regulation 9(5) direction itself? The fourth preliminary point is that HMRC accept that an obligation to make a Regulation 9 takes precedence over a subsequent Regulation 13 determination. We can see that in paragraph 20. Paragraph 19, my learned friend says, in addition, then new skeleton arguing the appellants make more detailed submissions concerning the position once an appeal has been made to the FTT against a refusal of a request under Regulation 9. It is submitted that if the FTT sets the refusal aside, and technically that's wrong, the FTT doesn't set the refusal aside, it says it directs you to make a Regulation 9 direction. The position is that HMRC had been under an obligation at the date of refusal to make a direction. That takes precedence over any subsequent Regulation 13 determination. The implication of this is that HMRC must have abandoned their position that Regulation 13 deprives the first-tier tribunal of jurisdiction, or prevents them considering the Regulation 9 refusal appeal. Because this is explicitly concerned with a situation where there is a Regulation 9, a Regulation 13 is subsequently issued, but the FTT nevertheless goes on to uphold the appeal and direct Regulation 9. So HMRC must be accepting that the Regulation 13 determination doesn't take away the FTT's jurisdiction to hear the refusal appeal. And again, that's different to what the High Court's held. It's different to what the First Tier Tribunal said in the cases relied on below for that proposition.
Is there a particular paragraph in the High Court decision where
It's in two places, but at the very end as well, where Mr. Justice Warden goes through and confirms that the FTT's been getting this right. I'll just find it for you.
He says it in paragraph 53.
Yes, that's the one where I think. And that's a significant development, because that means accepting that even though there's an extant Regulation 13 determination, HMRC can be ordered or directed by the First Tier Tribunal to issue a Regulation 9.5 direction, because that's the circumstance Mr. Simpson is referring to. He's saying there's an on-foot refusal appeal, a subsequent Regulation 13, but nevertheless the outcome of the refusal appeal is to direct HMRC to issue a direction. So HMRC must be accepting that the FTT can direct HMRC to issue a Regulation 9.5 direction, even though there is an extant Regulation 13 determination. And I've already made the point that the First Tier Tribunal can only order HMRC to do things they have the power to do. So it must follow that HMRC do have the power, on these paragraphs, do have the power to issue a Regulation 9.5, even though there's an extant Regulation 13 determination. And those four preliminary points add up to my overall observation and submission that it's not clear what we're arguing about anymore. We're very close, just not not sitting right beside each other. And the significance of that is that there doesn't seem to be any purposive reason for rejecting my interpretation, because Mr. Simpson gets somewhere very close through his alternative means.
Unless the words simply don't permit it.
Which is not actually what Mr. Simpson doesn't even submit that, which was going to be. So I'm now turning to my submissions on the ordinary meaning, and I made the observation, which was made below, that there's a difference in wording, and the wording we're concerned with is that a Regulation 9 direction does not apply to an amount determined under Regulation 13. So I'm now at paragraph 7 of my supplemental skeleton argument. My submission on ordinary meaning, you can see, is that an available ordinary interpretation is that a Regulation 9 direction can be issued in respect of an amount, but will not for the time being be operative, i.e. apply to that amount, whilst there is an extant Regulation 13. and I make the observation that saying that the Regulation 9 does not apply to the Regulation 13 amount seems to, at least implicitly, assume that the Regulation 9 direction exists and otherwise would apply. How does Mr. Simpson argue the point? Well, if we go to his original skeleton argument for this appeal, please, which is in, I think it's in the core bundle, unless you've got it separately. I'm on page 64. Paragraph 6. And the wording, the way Mr. Simpson phrases it, in the second sentence.
Sorry, which paragraph?
Paragraph 2, my lord.
2.
Paragraph 2 on page 64, and the same thing comes up at paragraph 21, which I'll show you in a
Yes,
moment.
I was going to say it was in 21. Yeah.
It's the same point, my lord. Almost the same wording. The respondents submit that is to be interpreted as meaning that where one of their officers has made a determination under 13.2, any decision made thereafter under 9.5 cannot affect the amount due by the addressee of the determination already made. A decision made under 9.5 in those circumstances would to that extent have no purpose, and HMRC therefore have no power to make a decision. So the logic of that argument is that we could make a direction, but it would serve no purpose, therefore there's no point in us having that power. But that's very different to saying, reading the words as written, we don't have that power. It's actually quite a different principle of interpretation. It's saying that legislation should not be interpreted as conferring a power on a public authority if the exercise of that power has no purpose. That's actually the implicit principle my learned friend's arguing for there. He's not saying that on the ordinary meaning we can't issue a decision. He's saying, well, if we did issue one, it wouldn't do anything. That's pointless. Therefore, we shouldn't have the power. Now, there's two observations I make in respect of that. First, there's no authority for that proposition that we should not interpret Parliament, or in this case, the statutory regulation, as conferring a power that has no purpose. But secondly, clearly it does have a purpose. And all the adjustments and additional points Mr. Simpson makes, and all the points I make, show that there clearly is a purpose. And so it seems, given that that argument there hinges entirely upon the proposition that there's no purpose. That's the middle sentence. A decision made under 9.5 would, to that extent, have no purpose. If that's wrong, if it does have a purpose, that argument fails. The same point as my lord, Justice Lewison, referred to, is at 21. It's almost exactly the same point. You'll notice at the end of 21 the contradiction between what my learned friend now says about grounds of appeal and what was previously said. The final sentence of 21 is, nor is there any competent ground of appeal to the first-tier tribunal. The determination should be reduced on the basis of a Regulation 9.5 direction.
Sorry, I was looking at the wrong skeleton. 21.
So this is the original skeleton argument.
Yep.
Paragraph 21, very last sentence. no competent ground of appeal based on Regulation 9, whereas now we see the opposite. The consequence of the do not apply wording in my submission, that's the point I make at 9, is that if HMRC inadvertently issued a Regulation 9 direction covering an amount, part of which had been determined under Regulation 13 and part which had not, that doesn't mean that the Regulation 9 is invalid. It just means it only operates in relation to the non-Regulation 13 amount. And that demonstrates the implication in my submission of the words do not apply to. So the Regulation 9 can be respective, but whether it operates is a different question. My second submission, paragraph 10, is the distinction between the wording in relation to Part 1 and Part 2 of Regulation 13.
Sorry, can we just
Of course.
pause a moment? So you're saying that HMRC make a direction under Regulation 9(5),
Yes.
and that's a direction that the contractor is not liable to pay the excess to HMRC.
Yes.
And we know that that is the difference between what the contractor was liable to deduct and what he actually deducted.
Yes.
So indirectly, that is quantifying something. Is that what you say?
Yes, but you could have situations where HMRC subsequently become aware of more facts and a further determination under Regulation 13 is issued, such that part of the sum is covered by Regulation 13 originally and parts are not. So the point is just that HMRC that part of the sum might be covered by Regulation 13 at the time and part of it might not. Because HMRC may take the view, well, in relation to this failure to deduct and pay over to us, reasonable care was exercised. We're not going to determine that. Here's your Regulation 9(5). But in relation to another part, well, we don't think you did exercise reasonable care. That might relate to a different subcontractor. So you can imagine situations where there's not complete overlap between the Regulation 9 direction and the Regulation 13. And my simple point is that in those situations, the do not apply wording doesn't mean that there's any fundamental validity problem with the Regulation 9 direction. It's simply that it doesn't operate for the time being. And that's simply because of Regulation 13.3. But then there will be consequences of that because presumably the Regulation 13 will be appealed. So it's no more than a development of the wording does not apply to and how that might practically.
Yeah.
I don't think it carries us a great distance. I wouldn't want to do too much with it. In my submission, submissions 2 onwards carry us a great distance. We need to travel a great distance because there is a distinction between the way that Regulation 13.3 deals with an extent Regulation 13 determination as compared to a Regulation 9 direction. And if the court wants to remind itself, that's on page 44 of the authorities bundle, tab 2. And the wording in relation to a Regulation 13 determination is that it must not include amounts in respect of which a direction has been made, whereas a direction does not apply to amounts determined. So
how would the language of do not include work? Are you saying that it would have been open to the draftsman, assuming the rest of the structure of the subparagraph was the same, simply say directions under that regulation do not include amounts determined under this direction?
It would have said must not include. So,
but include is the wrong verb, isn't it?
no, in the second, so in the first part it says Regulation 13 must not include Regulation 9 amounts.
Yes,
And
but
the
that's
second
because the
part-
governing noun is determination.
Yes, and then the second part it could have said directions under that regulation must not include amounts.
Must not
determined.
include.
You could have used exactly the same wording, and that would fit with the High Court's hypothesis that this is some symmetrical way of dealing with this situation whereby whichever one gets there first wins, essentially.
But the question being asked is whether include would be an appropriate word in relation to a direction.
The direction itself under 9.5 is a direction that the contractor is not liable to pay. So a direction that the contractor is not liable to pay does not include amounts. It would be clumsy English, wouldn't it? Apply to is the natural verb.
Well, why can it not be said that a direction, which is presumably some sort of notification, that direction / notification must not include this type of amount? There's no problem with saying that in my submission.
You get there sort of indirectly by identifying the excess, I think, on your interpretation, because the direction is that there's no liability for the excess, and that is what the contractor should have deducted minus what he did deduct, which is an amount. So you can work out the amount through the formula.
Yes, but you may not satisfy condition A or B in relation to the whole amount. Let's say one subcontractor has paid and accounted for tax and the other one hasn't. The excess would be the combined amount. The direction under condition B should only cover the former. And so the amount referred to in the direction will not necessarily be the total excess. It'll be the amount determined by HMRC to have satisfied, in relation to which they're satisfied that condition A or B is met.
One possible scenario is this, is it, that the contractor engages a subcontractor who in turn subcontracts electrical work or whatever it is to another subcontractor.
Yeah.
The contract is between the main contractor and the head subcontractor.
Yes.
The deduction under that contract is for everything that's due to the main subcontractor.
Yes.
Between subcontractor and subcontractor, there's another contract which should produce another deduction, and it may be that the bottom subcontractor has in fact paid everything due, whereas the head subcontractor hasn't. Is that the
Well, I'm
sort
not
of
sure how that
situation you're
would, because
positing?
the onward payment would be a deduction for the middle person. So I'm not sure you could end up with a situation where the liability rests in the middle. So in that situation, this is thinking out loud, the middle contractor, if I can call them that, would have an income amount of whatever's paid, and then an expense amount of whatever's paid onwards. And then you would check whether they paid tax on that amount, assuming they have. And then they would have their own CIS situation in relation to their onward payment.
Is your example is perhaps a more simple one where A engages two different
Yes.
contractors, should have deducted tax on paying both of them,
Yes.
didn't. In relation to one of them, the revenue is satisfied that they have paid their tax.
Yes.
In relation to the other, the revenue aren't satisfied.
Yes.
So the full excess is the full amount that hasn't been deducted.
Yes.
But the revenue are prepared to issue a direction in respect of
Yes.
only part of that.
Yes.
Is that the scenario?
That's the scenario I use to illustrate the point that there does have to be some decision making as to the amount that goes in the direction.
The difficulty I have with that, Mr. Firth, is
Yes.
that under primary legislation, the deduction works in relation to a contract. And you're positing two contracts, so you've got two quite separate deductions which have to be made. So I don't at the moment see how the revenue can issue a composite direction in relation to two contracts, because it's contract by contract, which is why I wondered whether you were thinking of a building contractor and an M&E contractor and an electrical contractor and a sort of chain of contracts.
Well, even in relation to one contractor, if you may have a series of payments over time, and some of which have been paid, and taxes being paid, or some of which reasonable care was taken. So I accept my lord's point that maybe we do need to look at this on contract by contract basis. Sorry?
13.4.
Yeah. Yes, that deals with Regulation 13. Determinations may cover all or part. We're talking about Regulation 9, which my submission may cover all or part, because there may be.
Okay, but is the point being made that Regulation 13.4 does envisage a global determination covering more than one subcontract?
Well, that seems to be right from B1, a class or classes of subcontractor. I mean, the point I started with is that.
Would that explain also why, it's been slightly puzzling me, not sure where it goes. 13.3 talks about a determination must, da-da-da-da-da, and directions, plural, rather than a direction does not apply. Or is that just, again, slightly loose drafting? I think this has always been one provision, has it? There's never.
Yes.
I just wonder whether that might, if the drafting history showed that two different provisions have been thrown together.
No, this has always been a composite.
Right. Okay. I don't see an obvious explanation for why it doesn't say and a direction rather than and direction. But I'm not sure where that observation gets us.
I know at the point, my lord, I don't think I can take it any further on.
No, well, there's probably nothing in it, except it may show that this is not terribly tightly drafted. And that the second limb 2 was drafted in a slightly different way from limb 1.
Well, that was the High Court's observation. It said, well, we can't read too much into that. My submission, as you'll see from my submental skies, is first of all, prima facie difference in language may connote a difference in intended meaning. I accept, this is Levin, paragraph personal finance, I accept that Lord Sumption there says, well, that is readily displaced if there's another plausible explanation for the difference. But then we come on to my submission that actually they're dealing with situations that are not symmetrical. And this is I submit, the answer to why is there a difference in meaning, a difference in wording and therefore outcome. And that this is the point at paragraph 16, submission 3. Because Regulation 13.3 deals with a situation where Regulation 9 direction has been issued. And there is no basis within the regulations whereby a Regulation 9 direction, once issued, may cease to exist. So once you've got that confirmation from HMRC that you're not liable for a particular sum, there's nothing in these regulations that takes that away from you. In contrast, under Part 2, where there is an extant Regulation 13 determination, well, there is a right of appeal against that determination, and therefore the regulations do envisage and expressly contemplate that the Regulation 13 determination may cease to exist. And that will happen following a successful appeal. And so we're not dealing with symmetrical situations here. The Regulation 9, once made, will never cease to exist. Therefore, there's no point in providing for the possibility of a Regulation 13 in relation to that amount, because the Regulation 9 is never going to cease to apply to it.
Is this in effect advancing what the judge described as the hibernating construction?
Well, logically, if I'm saying a Regulation 9 can be issued whilst the Regulation 30 is extant but does not apply to it, I am adopting my interpretation leads to that outcome. I don't call it the hibernating approach, but nevertheless, I am still advancing that that effect. But I don't agree, as you've seen later, with the High Court's observations as to that being artificial and subversive.
Yeah.
Certainly no more so than the contrary. So yes, the Regulation 9 exists, and this is my first submission. The Regulation 9 exists in respect of that amount, but for the time being doesn't operate in relation to it. You can call that hibernating if you want to give it a colourful description, but that's how I say it works. And there is a purpose to that, and that's the point of submission 3. There is a purpose to that Regulation 9 existing, which is because the Regulation 13 may well cease to exist. And in fact, the Regulation 9 will provide, on appeal to the FTT, a reason for allowing that appeal. And then when the Regulation 13 ceases to exist, the Regulation 9 can now apply. And that is, in my submission, how this works. Rather than having a care and management power that says we can't issue a Regulation 9 but we'll just agree not to collect it, there is a mechanism through the legislation that leads to that outcome. But that distinction, that lack of symmetry, is clear. And below that, Mr. Justice Fordham said the nice thing about his lordship's interpretation was it produced a symmetrical result. But my answer to that is, well, we're not dealing with symmetrical situations, so we shouldn't necessarily expect a symmetrical result. This also addresses my learned friend's submission on interpretation, because as I showed you, his logic is there's no point in us issuing a Regulation 9 once there's a Regulation 13, no purpose in that, and therefore there's no reason for us to have that power. That was paragraphs 2 and 21, which I've shown you. But this already shows that there is a purpose, because the Regulation 13 may, and indeed the regulations anticipate, cease to exist upon a successful appeal. And so therefore there is a purpose. And in fact, the existence of a Regulation 9 would be a reason to allow that Regulation 13 appeal. We then move on to the consequences of the High Court's interpretation. That's point 4.
Right, can I just put this to you? If you're right, and HMRC make a Regulation 13 determination, you then manage to persuade HMRC that one of the conditions is satisfied and they issue a 9-5 direction. Is that the peg on which Section 30A of the Taxes Management Act allows the assessment to be withdrawn?
If you've appealed
Is that the statutory peg? Because you've majored on that, saying, well, they can't withdraw it unless there's something in the Taxes Act which says they can. And on your interpretation, if I've understood it, once the 9-5 is in existence, the Regulation 13 direction shouldn't include it, or can't include it. Is that right? And it can be withdrawn? Is that how you get into 30A?
It's close, my lord. This is actually my point 7.
Right.
So we have to find an express basis in the Taxes Act for withdrawing or altering a Regulation 13. The only express basis is in response to a valid appeal. That's why I showed you sections 31 and 31A. Therefore, my submission is that you must be able to appeal a Regulation 13 direct determination in reliance on Regulation 9. The way I put that is that to an appeal on the basis that one either has been made or will be made. And then that valid appeal against the Regulation 13 provides the statutory basis for either the parties to agree under Section 54 or the first tier tribunal, a final appeal, to say we now allow the appeal against this Regulation 13 because we can see there was a Regulation 9. So it's not merely the existence of the Regulation 9, but the Regulation 9 then feeds into the appeal process against the Regulation 13.
I think it would also follow from that if there was no effective appeal against the Regulation 13 determination, or the appeal was finally determined before anyone got round to making a decision about Regulation 9, then that would be too late.
Yes.
In other words, once you've got and because there's a point I think being made about this is all open-ended.
Yes.
To which the answer may well be, if I'm right about what I'm saying, is that as soon as one way or another, as soon as Regulation 13 determination is final,
Yes.
whether because it's not appealed or the appeal process is exhausted,
Yes.
then you've lost your chance.
Yes. And that's equivalent to other situations in which you don't appeal an assessment and then think of a really good argument that would have potentially allowed you to win that appeal. Well, it's too late, sorry. And that's a point I make and accept in my skeleton. And it deals with the High Court's belief that, well, this just seems to be open-ended. You can at any time, 10 years after the event, after the Regulation 13 determination, turn up and ask HMRC to exercise their powers. And if you succeed in that, then the Regulation 13 determination suddenly falls away. And my submission is no. The assessment or the determination stands good unless it's altered or withdrawn in the course of a valid statutory appeal against the Regulation 13 determination. My fourth point deals with the consequences of the High Court's interpretation. And I've already noted that my learned friend seems to depart from the High Court in this aspect, because the High Court confirmed the view of the first tier tribunal that if there is an extant refusal appeal under Regulation 9, and then subsequently HMRC issue a Regulation 13 determination, they cease to have jurisdiction to consider the refusal appeal. And we can see that in the North Point case, which is behind tab 14. The background facts are set out in a number of list paragraphs, but at page 454 we can see subparagraph 15. On 28th of February 17, HMRC's technical team made the decision they were not satisfied with the criteria for 9.3 or 9.4 were satisfied, and the claim for relief under those provisions would not be granted. And then up to subparagraph 18, on the 5th of April, HMRC issued decision notices in relation to both the Regulation 9.3 and 9.4 claims, along with determinations to the appellants. And you can see at 19 they were then appealed. This is the appeal against the refusal under Regulation 9. Jurisdiction is then raised and considered. Paragraph 7 on page 459. HMRC submitted that once a determination has been made under Regulation 13, it is not open to them or to this tribunal to make Regulation 9.5 direction. I mean, that must be a slip. It must mean we cannot direct HMRC to make a Regulation 9.5 direction. This is clear from the regulations, the decision in Ormandy, HMRC's compliance book, and Ms. Murthwaite's evidence. You then see at paragraph 8, the issue as to whether an appeal can be brought under Regulation 9.7 once a Regulation 13 determination has been made, we will refer to as the jurisdiction issue. HMRC submission is set out in a bit more detail in paragraph 10. Perhaps I can ask you to read that to yourselves.
Just paragraph 10 or?
And then paragraph 12 is the tribunal's conclusion.
Yeah, so they accept that interpretation in paragraph 10.
Yes, they agree with HMRC that we're defunct. Once there's a regulation 13, we cannot consider this any further. And that's what is approved by the High Court as the logical conclusion of its interpretation.
That's the judge's paragraph 53, I think.
And he earlier goes through decisions and sets out what they decide. But at 53, he approves it, yes. I'm at paragraph 23, or 22 and 23 of my skeleton argument. I already made the point when I was going through the regulations, Regulation 9, that nothing in those provisions says anything about a refusal notice being given on the basis of a Regulation 13 determination, or HMRC being precluded, the tribunal being precluded from allowing an appeal against a refusal notice because of the Regulation 13 determination. Instead, the task of the tribunal is simply to determine whether condition A is met. Whether the Regulation 13 determination or not is not relevant to that appeal. And then you consider the consequences. Because on the consequence of the High Court's interpretation is that HMRC at any time can render an appeal defunct by issuing a Regulation 13 determination. And the consequences of that are astonishing in my submission, not properly considered by the High Court. And you can bring out these consequences, as I do at 27, by noting that this Regulation 13 determination may arise not simply early on in the process, as it did in the North Point case. It could arise before the FTT hearing, after the FTT hearing, but before decision, or there's an onward appeal, and before the upper tribunal considers it, or this court considers it, and obviously before decision. So you could have a situation where this court was hearing an appeal against a refusal of a Regulation 9 notice, and between the court hearing the case and issuing its decision, a Regulation 13 determination is issued. And that seizes away the jurisdiction to make that direction. Because
I'm not sure about that.
Well,
this court has all the powers of the lower court. So if the lower court could have made the direction, this court can, can't it?
Well, that's the point. The first tier tribunal says we can't do that.
Oh, no, follow. But you were talking about what happens if we reserve judgment and then HMRC issue a Regulation 13
Yes.
determination. We have the same powers as the lower court. Whatever the lower court could have done, we can do, I think.
So my lord's saying that
if at the date when the lower court made its decision, it could have issued or directed HMRC to issue a 9-5 direction, why it would be surprising if HRC could take that away, even if their construction of Regulation 13 is correct.
because it's the logical consequence of Regulation 13.3, which says that you can't, HMRC cannot do, and it doesn't apply to, an amount that's included in the Regulation 13. So you'll be ordering HMRC to do something that on their own, on this interpretation, they don't have power to do.
Yes, I see. Yeah.
But even if you were, my lord's initial view on this were right, that's in a sense icing on the cake point for you, because you say it's sufficiently astonishing if they can take away the right of appeal before it gets to the FTT.
Yes, this is just developing that point. And also tying it in with the time limits, because the time limits are important, because a lot of the focus below seems to be on the, well, HMRC won't abuse it, and if they do, we can sort that out. But actually, HMRC may be compelled to issue a Regulation 13 determination simply to protect the revenue, and this is the point I make, and I think my learned friend accepts that they would, if the time limit was coming up for a Regulation 13 determination, 4 years, they would issue it simply to protect the revenue's position. And so depending on where you are in that 4-year period, they may have no choice other than to issue the Regulation 13, not for abusive reasons, reasons, not the sort of reasons that you could go to judicial review and say they're acting in bad faith or improperly, but for perfectly proper protection of the revenue reasons. And that point isn't addressed below. In terms of giving legal basis to this submission, at paragraph 31, I refer to the authorities, Supreme Court authorities that say that courts should steer clear, if they can, from interpretations that produce unworkable or absurd results. I'm sure those are familiar to this court. I don't need to take you to them. But then I equally, and perhaps more directly, refer you to the authorities on the denial of access to the courts. And I refer to two cases there. The first is Unison, which I'm sure this court is familiar with in terms of the legality of fees for employment tribunal claims. I don't know if I need to show you the paragraphs, but I've summarized at 33 the principles I say you can get out of the Supreme Court decision.
Speaking for myself, I wouldn't have thought it was necessary to go to Unison itself, but if either my lord or my lady want you to.
No.
I'm grateful for that indication. And in my submission, at 34, the High Court's interpretation violates each of these principles, because there are no clear words in the statutory enactment allowing the right of appeal once granted to be taken away or rendered defunct. The impediment is not authorised by any primary legislation. The interpretation, and this is significant, directly permits HMRC to usurp essentially the function of the tribunal. HMRC can take a step that will prevent the tribunal having jurisdiction to consider something that before that step it had jurisdiction to consider.
That is effectively the result arrived at in the FTT case you just
Yes.
to, isn't it?
Yes.
They said we can't do this.
We can't, no. We have no jurisdiction to consider your appeal. And implying that the principle that the court should adopt the least intrusive interpretation, well, that would be mine, because it doesn't lead to this result. We get the same points from Hayworth in the Supreme Court, which considered follower notices. I've given brief background in paragraph 35. I'm sure this court's familiar with them, but essentially, if HMRC issue a follower notice to somebody, it's basically saying we think there's a decision of the court that would lead to your appeal being dismissed, and therefore if you don't give up your appeal, you'll be liable to a big penalty if you lose. And HMRC sought to argue, well, it merely discourages people from exercising their rights of appeal, and therefore it doesn't fall within the Unison principles, and the Supreme Court said no. I've quoted that at 61. We can go to it if there were to insist, but frankly, I think 61's the heart of the matter.
Yeah.
And not only would the actual existence of a Regulation 13 determination render the appeal defunct, but the possibility of it would discourage people from exercising that right. Because, and this is a point that's made by the Supreme Court in Unison, is that even if in theory you could exercise your right may be irrational to exercise that right, or you may consider it futile. For example, I think they give the example of a £360 fee to pursue a £500 claim that you may or may not win. Well, who would do that? It would be irrational. And the possibility that your opponent, HMRC, could and may have to, depending on time limits, may have to issue a Regulation 13 determination that renders the whole appeal defunct, having spent who knows how much on fees and spent how much time, would seriously discourage people from exercising that right. we then come to the controversial paragraph 37. I mean, it wasn't intended to say anything more than I've already said, but just simply to say, and by the way, this also fits into that line of case law under Article 6 that rights are intended to be practical and effective rather than illusory or nugatory. I mean,
it did occur to me that the one thing it might add is that if we were not persuaded of the natural meaning
yes.
of Regulation 13.3, you could be, though you don't appear to be doing so expressly here, invoke Section 3 of the Human Rights Act and say basically you can adopt a strained construction as long as it's, quotes, possible.
Yes.
Now, if you're not running that argument, I agree it doesn't really add anything.
I don't think I need to. I mean, if you've seen my submission that an available interpretation of the ordinary words is that there's a difference in language and this is the reason. So we have a firm hook, if I'm right about these purposive reasons, to arrive at the correct result. And I would draw the court's attention to what the Supreme Court said in the filed case, which is behind tab 16 at paragraph 6. Because one of my learned friend's points, I think, is, well,
You want to go there?
Just because my learned friend says if the words are plain, that's the end of it. And in my submission, that's not quite right. So it's tab 16, paragraph 6 on page 500.
Paragraph
6, my lord.
6.
Sorry, I'm behind. Which page?
500, my lord, behind tab 16.
Even where they appear to be ambiguous, you've got to put it into its context.
Yes. Which I'm sure this court's very familiar with. You can find ambiguities based on the absurd results they lead to. And that's the point I get from McCool and the first port property case, which I refer to my skeleton. That the court will in fact, you can use a strained construction to avoid those absurd results. I don't think we need to go to section 3 because we're just nowhere near a situation where there's such clarity against me that I'm arguing against it.
Well.
So the cases you've just referred to are...
Yes, I mean, I can show you them.
They're just the references.
Paragraph 31 of my skeleton has them, my lady. So it's first port property.
Oh, thank you.
Paragraph 54, R. McCool.
Oh, those ones, yes.
Yes.
Thank you.
They talk about absurdities, and absurdity being a broad concept that includes unworkable results, and that the courts will obviously work as hard as they need to within permissible bounds to avoid those results. And so even if you have something that appears clear, if it leads to absurd or unworkable results, then you have another look to see if you can find another interpretation. And that, in fact, perhaps we just look at McCool because they made that point, and then they say, well, if there is a workable interpretation, it should be adopted. So tab 11, please. And on page 3. Paragraphs 23 to 24 set out the general principles in relation to absurdity. And then at 26, the Supreme Court says, just by F, well, it says we do consider this would lead to unworkable results, and therefore by F, I consider therefore that if there is a workable interpretation of legislation which allows post-2003 offences to be dealt with under the 2002 Act, that interpretation should be adopted. So unless my interpretation is unworkable, just cannot possibly be squared with the wording, then if the consequences I say do follow, then it's the interpretation you should adopt. I'm about to go into point 5. I know the time. I'm in the court's hands as to whether I keep going.
Yes, that's it. Well, it looks to me, how much longer are you going to be?
I've got point
But you've got 5, 6, and 7.
Not very long. I mean, I'd be surprised if I was more than half an hour.
No, quite. I might be content to sit on to here for 0.5, but if it's a natural break, I think we've got plenty of time.
Yes, thank you.
Thank you very much. 10:30 tomorrow.